Hi, this is Usha. Welcome to Rathod's IAS classes. Today in this lecture, we are going to see the fourth chapter of Laxmikanth, that is the Preamble of the Constitution. So before getting into the topic, let us say some of the introduction regarding this preamble. So first of all, what is a preamble? So whenever you are starting or reading the new book, first of all, you will open the preface paper and you will read this preface. So after reading this preface, you will understand what is the idea of the author and what you are going to gain after reading this book. In the similar manner, the preface of the Indian Constitution is also there, that is simply the preamble. Preamble, it is a preface of the Constitution. In simple words, it is a mirror of the Constitution. So if you want to define the preamble, it sets the ideals, it sets the goal which the makers of the Constitution intended to achieve mainly through that Constitution. So to understand this preamble in the great detail, you should remember two important cases. The first one is the Golaknath versus the state of Punjab. In this case, Supreme Court held that the preamble contains in a nutshell its ideals and its aspirations of the makers of the Constitution. And the second important case is the Re-Berubari Union case of 1960. So in this case, Supreme Court held that preamble, it is a key mainly to open the minds of the makers of the Constitution. So from where this preamble was came? So this preamble, it is mainly based on the resolution, that is objective resolution, which is passed by the Pandit Jawaharlal Nehru in the Constituent Assembly on 13th December 1946. And later on it adopted by the Constituent Assembly on January 22nd, 1947. So later on they have the mainly four parts. The first one is a source, that is a we, the people of India, and the second one is the nature. It includes sovereign, socialist, secular, democratic, republic. And the last one is the goals, and these goals include justice, equality, liberty, and fraternity. And the last part, it is about the date of adoption, that is the 26th November 1949. So let us see these important keywords like the sovereign, socialist, secular, democratic, republic, and also the equality, liberty, fraternity, and justice in detail. So this will complete our discussion on this preamble of the Constitution. So let's get started here. If you see the first important thing, the term preamble, it mainly refers the introduction or the preface of the Constitution, and it mainly contains a summary or the essence of the Constitution. So one famous jurist, that is N.A. Palkiwala, he said that preamble, it is the identity card of the Constitution. If you see the preamble of the Indian Constitution, it is mainly based on the objective resolution which is passed or moved by the Pandit Jawaharlal Nehru, and it is adopted by the Constituent Assembly on January 22nd, 1947. And it has amended only once, mainly through the 42nd Constitutional Amendment Act, and it added the words like socialist, secular, and integrity. So this point, it is very important regarding the prelims point of view. Okay. So let us see the text of the preamble. If you see, the text says, we, the people of India, having solemnly resolved to constitute the India into a sovereign, socialist, secular, democratic republic, and to secure all its citizens justice. It includes social, economic, and also political, and liberty of thought, expression, belief, faith, and worship, equality of the status and of opportunity, and to promote among all, and fraternity, assuring the dignity of the individual and the unity and integrity of nation. In our Constituent Assembly, this 26th day, November 1949, do hereby adopt, enact, and give to ourselves this Constitution. So this preamble have mainly four important parts. The first one is the source, that is the people of the India, and the next one, it is sovereign, socialist, secular, democratic republic. If you observe this sentence, there is no commas between. So this represents the nature of our Indian Constitution. And the next one is the objectives. They include social, that is justice, liberty, equality, and fraternity. And the last one is the date of adoption, that is the 26th November 1949. So these are the important 4 ingredients of our preamble. And let us see the keywords in this preamble. The keywords include sovereign, socialist, secular, democratic, republic, justice, liberty, equality and fraternity. So the first important keyword that you should remember is a sovereign. Here, what is the meaning of the sovereign? Sovereign means we are independent in simple. We are not a dependent, we are not a dominion. We are independent, okay? So there is no authority above and we are free to conduct our business either internally or externally. So being a sovereign state, we can acquire the foreign land and we can cede our part of the land to the foreign country. So this is the simple meaning of this sovereign. And let us see the next one, that is socialistic. Socialistic, it is a word which is added through the 42nd Constitutional Amendment Act of 1976. But before adding this constitutional amendment, the socialistic, which is also the part of our constitution, we see this socialistic mainly in the directive principles of the state policy. And the next one is the Indian brand of the socialism. It is a democratic socialism. Whenever we are talking about the socialism, we can have the 2 types of the socialism. First one is a democratic and second one is a communalistic. Here if you see the communalistic, it means the means of production always in the hands of the government. There will be no private enterprises that is present. And if you see the democratic socialism, we have the faith in the mixed economy. That means we have the public enterprises, we have the private enterprises as well. And if you see the democratic socialism, the main aim of this democratic socialism, which is adopted by the India, the main aim is mainly to end the poverty and end the ignorance and end the disease and end the inequality of opportunity. And if you see in the Indian socialism, it is a blend of the Marxism and also the Gandhianism. So we can see the Gandhian socialism that is reflected in our Indian constitution. And let us see the next important keyword, that is secular. The term secular, it is also added by the 42nd Constitutional Amendment Act of 1976. If you have the secularism, there are again 2 concepts. The first one is a negative secularism and the second one is a positive secularism. In the negative secularism, it is mainly followed in the Western countries. Here, the religion which is entirely separated from the state. And if you see the positive secularism, which is mainly adopted by our Indian constitution, in which irrespective of the religion, all the religions are equal and all the religions, they were supported by the state. That means the state have the no religion, okay. So this is the Indian concept of the secularism. And the next important keyword is the democratic. Here, what is the meaning of democratic? Demo means people, pratic means the rule. It means the rule of the people. Here, if you see the democracy, we see mainly 2 types. First one is a direct democracy and the second one is the indirect democracy. So if you see the direct democracy, the example is the Switzerland. So what is the difference between the direct democracy and the indirect democracy? The direct democracy means the people exercise their supreme power directly. Okay, the people have the supreme power, they will exercise directly. The example is a Switzerland. So the 4 important devices of this direct democracy we already discussed. They are the referendum, that is recall, initiative and plebiscite. And if you see the indirect democracy is the people do not have the direct authority. People will elect their representatives. The representatives which are elected by the people on the behalf of these people, they make the laws. Okay, so this is the indirect democracy. If you see here indirect democracy, on the other hand, the representatives, they are elected by the people and these people, the representatives who are elected by the people, they exercise the supreme power and thus they carry the government and they will make the laws on behalf of that people. And this type of the democracy, it is also called as a representative democracy. We see the representative democracy that is present in India but not the direct democracy. And when you are talking about the democracy, there are again 2 types, presidential and the parliamentary. So if you see the India adopted the parliamentary form of the government rather than the presidential form of the government, which is adopted by the USA. So if you see in the presidential form, there is a legislative, there is executive. There is no link between the executive and the legislature. They are the 2 different entities. And if you see in the presidential form of the government, there is executive there is a legislative. There is a proper coordination, the cooperation that is seen between the legislative and the executive. So in this, there is the executive which is responsible to the legislative for its actions. So there is a proper coordination and also the cooperation that is seen between the legislative and also legislature seen in the parliamentary form of the government that we adopted. And let us see the next one. The term democratic, it is used in the preamble. It has a broader sense. It will embrace not only the political democracy but also social and also the economic democracy. So if you see the political democracy, it is given by the fundamental rights, and if you are talking about the social and the economic democracy, it is provided through the directive principles of the state policy. And let us see the next word, that is the republic. So what is the republic? To understand the republic, first we have to see the monarchy. Monarchy means the king is there. The king is above all. And the king's son will become the next king. So we see the hereditary which is present in the monarchy. So this opposite of this monarchy, it is republic in the simple sense. So if you see a democratic polity, it can be classified into two classes. The first one is a monarchy and the second one is a republic. In the monarchy, he will be the head of the state, that is either king or a queen. He or she will be the head of the state. They enjoy the hereditary position. That means their son become the next king. Okay, in that way, the son, the grandson, great-grandson, they will become the kings of the next generation. But if you see in the republic, it is opposite to that of the monarchy. If you see the head of the state, he is always elected either directly or indirectly by the people, and there is no hereditary. So for the example of the monarchy, we can say Britain, and for the example of the republic, we can say USA, India, etc. The term republic in our preamble, that indicates India has an elected head, that is called as president, but this president is indirectly elected, that is a nominal head. And if you see the prime minister, who is directly elected by the people, the real executive. So either we have the directly elected or indirectly elected for a certain period of time, it is called as republic. And if you see the time period or the tenure for this prime minister or the president, it is for 5 years. And the republic also say about the two important things here. The first important one is the vesting of the political sovereignty in the people and not in the single individual like the king. So there is a political sovereignty which is present in the people, not in a single individual, that is a king, that is seen in the monarchy. And if you see the second important thing, that is there is absence of any privileged classes. Hence all the public offices, they are open for every citizen without any discrimination on the race or religion, caste, sex, etc. So let us see the next keyword, that is justice. The term justice in the preamble, that embraces three distinct forms. It includes social justice, it includes political justice, it also includes economical justice. So the justice in the preamble, which embraces mainly three types, and they are secured to the citizens of the India mainly through fundamental rights and also the directive principles of the state policy. And let us see about social justice. Social justice, it denotes equal treatment for all the citizens without any social distinction based on the caste, based on the color, based on the race, based on the religion, based on the sex, so on. So it means there will be no privileges being extended to any particular section of the society, and also improvement of the conditions of the backward classes and the women. So it also talks about there should be the improvement such that we have some exceptions in the fundamental rights, and we have the reservation for the SCs, STs and the OBCs and also women. And let us see about economic justice. It denotes no discrimination between the people on basis of the economic factors. So when you are talking about the social justice and economic justice, it is together called as a distributive justice. So this is an important word you can use directly when you are writing the mains answer. So what is a distributive justice? It is a combination of both the social and also the economic justice. And let us see the next one, that is a political justice. It implies that all the citizens should have the equal political rights, equal access to all the political offices, and they should have the equal voices in the government. So to understand this, one famous case is Lily Thomas versus Union of India. I will write here Lily Thomas versus Union of India. According to this case, Supreme Court held that if there is any member of the parliament or any member who want to contest in the election, if he went for the imprisonment for more than 2 years, he will be disqualified, such that it provides the political justice. And if you see the idea of the justice, that includes social justice, economic justice, and also political justice, they have taken from the Russian Revolution of 1917. So this is also very, very important regarding the prelims point of view. And let us see the next, that is the liberty. So what is the meaning of the liberty first? The term liberty, it means the absence of the restraints on the activities of the individuals. In 2018 prelims, you got a direct question regarding what is the liberty. The statement was taken from here. So if you're reading anything, you should be clear regarding what is the meaning of that word. So if you see the term liberty, it means the absence of the restraints on the activities of the individuals, and at the same time providing the opportunities for the development of the individual personalities. So if you see the preamble, it secures all the citizens' liberty, the liberty of thought, liberty of expression, liberty of beliefs, liberty of the faith, and the liberty of the worship, mainly given by the fundamental rights. And if at all any fundamental right of the citizen of the India, it is violated, then these are enforceable in the courts of the law. They have the right to approach the Supreme Court through the process of the writs. They can apply their writs. They are 5 types: habeas corpus, mandamus, certiorari, prohibition, and quo warranto. So if you see the ideals of the liberty, equality, and fraternity, they are taken from the French Revolution. The first one, it is from the Russian Revolution, and this is from the French Revolution that has happened between 1789 to 1799. So let us see the next word, that is equality. The term equality means there is the absence of the special privileges to any sections of the society, and it also provides the provision of adequate opportunities of all the individuals without any discrimination. So when you're talking about the equality, there are 3 types: civic equality, political equality, and also economic equality. So to ensure the civic equality, they are the fundamental rights. From Article 14 to Article 18 of Indian Constitution talks about right to equality. So let us see those rights. And Article 14 talks about the equality before law. Article 15 talks about prohibition of the discrimination on the grounds of religion, race, caste, sex, or the place of birth. And the next one is Article 16, which talks about the equality of the opportunity in the matters of public employment. And Article 17 talks about abolition of the untouchability. And Article 18 talks about the abolition of the titles. So let us talk about the political equality. Here, to understand this political equality, there are 2 statements. The first one is no person to be declared as ineligible for the inclusion in the electoral rolls mainly on the grounds of religion, race, caste, or sex. Because we follow the universal adult franchise. According to this universal adult franchise, the citizen who is not less than 18 years, he or she will have the right to vote. It is So it is the Article 325. So right to vote, it is a legal right or a constitutional right. And the second important one is the elections to the Lok Sabha and the state assemblies to be based on the adult suffrage. So Article 326 talks about the adult suffrage. So if you're talking about the economic equality, the first one that comes into your mind is the DPSP, the Directive Principles of the State Policy. According to the Article 39, it talks that men and women should have the equal right to an adequate means of livelihood, and it also talks that equal pay for men and the women for the equal work. There should be no discrimination based on the sex. And the last important word is the fraternity. So first of all, what is the meaning of the fraternity? Fraternity means the sense of the brotherhood. the constitution promotes this feeling of the fraternity by the system of the single citizenship. We have only single citizenship but not a dual citizenship, unlike the USA. Okay, so through this system of the single citizenship, our constitution is promoting the brotherhood. And also, if you see the fundamental duties under Article 51A of our Indian Constitution, it says that the duty of every citizen of the India mainly to promote the harmony and also the spirit of the common brotherhood amongst all the people of the India, transcending the religious, linguistic and also the regional and the sectional diversities. So this is the one important thing. The fundamental duties of the Article 51A also talks about the fraternity, that is a brotherhood. And if you see, the fraternity also ensure the two important things. The first one is the dignity of the individual. Second one is the unity and the integrity of the nation. So if you see here the word integrity, it is not present in our original constitution. The word integrity is again added through the 42nd Constitutional Amendment Act of 1976. So what are the three words that are added by this 42nd Constitutional Amendment Act of 1976? Socialist, secular and integrity. So let us see the next part, that is whether the preamble it is a part of the constitution or not. The first important case is Re-Berubari Union case. And this, according to this Re-Berubari Union case of 1960, it talks that preamble it is not the part of the constitution. It is not part of the constitution. And later on, in the Keshwananda Bharati case of 1973, it said that it diverted this statement or the judgment which is given in the reunion or the Re-Berubari Union case. And in this case, Keshwananda Bharati case of 1973, Supreme Court said that preamble it is a part of the constitution. Okay, returned. It is the integral part of the Indian Constitution. It overturned the judgment which is given in the Berubari Union case of 1960, and Supreme Court said that it is the integral part of the Indian Constitution. And if you see the amendability of the preamble, whether it is amended or not. So the question whether this preamble can be amended or not under the Article 368. If you are reading this Article 368, it is talking about the power of the Parliament to amend the Constitution. Whether under this Article 368, the Parliament have the power to amend this preamble or not. The first time this question arises in this Keshwananda Bharati case of 1973. So if you see this Berubari Union case, judgment it is given that preamble it is not the part of our Indian Constitution, we cannot amend it. But if you see this Keshwananda Bharati case, the judgment given by Supreme Court, it is the integral part of the Constitution. Whenever anything which comes under the part of the Constitution, the Parliament can amend. The Parliament have the power to amend the Constitution under the Article 368. So in this case of the Keshwananda Bharati case of 1973, Supreme Court came up with the one important term, that is a basic structure doctrine. So in this case, Supreme Court said that preamble can be amended, but the basic features of the Constitution cannot be amended. So finally, we can amend the preamble. So if you see, till now only once the preamble was amended, mainly through the 42nd Constitutional Amendment Act of 1976, and the three important words are added, that is socialistic, secular and integrity. By this we are concluding this lecture. I hope you understand the preamble. Thank you so much. Please subscribe to my channel. Please like, share and comment my videos. Thank you.